puff, puff, pass. True crime chat rats. Let's go! Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. True crime social where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rap pack. With my raps chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in the trap. Cause we coming through like that.
What's up, y'all? What y'all doing? Let's see what the fuck happens. I ain't even gonna talk about it. I am gonna talk about the wrenches though. So we will very particularly distribute those this time. And if we can keep it going, we will be very careful this time. But I don't think it matters. But yeah, I gotta remember how to do all this shit. It's been a couple of days. 4 or 5 days. Hope y'all can hear me. I'm trying to get all the settings worked back out, which is a pain in the ass. Should have done that already. What y'all been doing? I've been watching y'all kill it up in Discord. And I do got the video and all that, but I'm not gonna just go crazy and get busted. You know what I mean? But yeah, I didn't really watch too much of all this. Obviously, I watched Wrenchler, but I'd like to watch that again. I didn't watch anything from today, and it's only an hour, so it shouldn't be too big of a deal. What's up, Lawlene? Can you hear me now? You there? Yo, yo, yo. Probably got to set up your stuff again. I don't know. Yeah, so just bear with me. Got a bunch of crap to set up. So who showed up? I thought I saw Pinky in here. Did she leave already? What up? Angel, can you hear me? Okay, good. I see Pinky in there, but I don't see y'all in the StreamYard chat. StreamYard is. What about now, Lolly? Oh yeah, if you're in Discord chat, it won't show you up over here. What's up, Dean? Dino Marino. Yeah, I can't hear Lolly and either, Pinky. Cannot hear her. I know. I'm not in a big hurry. I got a bunch of crap. I gotta get set back up. Dean. There we go. My damn StreamYard needs to catch up. But you're gonna turn your fan off. What about now?
How about now? Can y'all hear me?
Oh, there she is.
Holy crap. Thank you, Dean.
Yeah,
We've all been in voice chat talking for like the last couple of hours. I didn't realize I had something still open in my phone.
yeah. Y'all like kids in high school on the phone back in the day.
Shut up.
Definitely.
We've been going over hairstyles and everything in Discord.
Good. I've been.
Glad you're here, Danny. We've missed you.
Oh, I know it's been a horrible few days. Horrible. Can't even tell you. I didn't think that it would matter that much, but it does.
I know it does. I'm glad you're here.
And there's a lot of hours we got to get back now from nowhere.
And my my frogs are back after all of these rainstorms too.
Yeah.
For all the people who enjoy my frogs.
But I am here. I just don't want to be on the cam. I'll get blowed up or whatever. But what happened today in court before we watch it?
Lots
It's
of
not, very,
motions.
not very long.
No, there were lots of motions. Basically, the defense dropped their the whole absent witness motion, but that doesn't mean they can't still argue it. It just means that Bev can't give an instruction about it. And then the prosecution dropped their argument about crap. I'm trying to think of the word where that Karen Reed was admitting crap. We've been in Discord talking about so much other stuff. My mind's off the case. Hang on.
It's all right. I ain't in no hurry.
Consciousness of guilt. Consciousness of guilt. The prosecution dropped their motion about consciousness of guilt, which doesn't mean they can't still argue it, but it means Bev can't give an instruction about it. They dropped the third party culprit, but that doesn't mean they can't still argue it, but Bev can't give an instruction about it. So basically everything's still on the table, but Bev's not going to give instructions about it. It's all up to the jury for how they see it, basically.
What's up, Dean?
Yo, what's up?
Oh, not shit. Just trying to get going after we crashed this motherfucker. Funny thing is, they will not tell me why.
They never do.
Well, they do when you get like
If it's copyright, because they legally have to.
Yeah.
But that's it.
Yeah. Oh, it's hard to hear the lawyers. I got it on channel 5 though. Channel 5 is usually a lot louder than.
You don't got shit. Oh,
yeah, I
shit.
do got shit, boy.
You ain't got shit on shit, bro.
I know. It was crazy. It was a great idea to do what we did.
If
So
you
I'm
guys thought we got fucking shitty last time, this is an all new channel and we're gonna get
Stop,
even.
Dean. Stop, Dean.
What? I'm just joking.
We can't even joke here, or else we'll get kicked.
yeah, I'm scared. I'm scared.
Wow.
But I got the Proton running.
Yeah, yeah.
It's slow and slows the stream down.
No, Pinky. No. Lally's not going to do the closing. Him and Unetti just argued the basically the jury instructions and the last standing motions, other than the one Alessi argued today about the whole sweatshirt curation instruction to the jury, which she did not sound interested in, no matter how horrible Lally's argument was. But no, obviously Brennan and AJ are going to do the closings tomorrow.
Yeah, I got a lot of stuff to set up in this channel. It's crazy. I forgot how
I
much
mean,
stuff.
while you're doing all that, can we just at least celebrate the first victory for TV on here? Like,
Oh,
that was
yeah,
awesome.
that was good. Definitely like that.
We all knew it was going to end up that way, but it's a shame that it had to go to a 3-day trial, like bench jury over that. It's ridiculous, but we all knew what the outcome would be, and hopefully it's just one of many not guilties we're about to hear.
Yeah, for sure. Is there anything other than him in the car talking about it?
Well, I mean, he's on Sex Cult right now, which
Yeah.
we were talking in voice chat. MJ could actually have stream for us. I mean, I'm in Sex Cult, Angels in Sex Cult. Like, I don't know how to stream it though, but I figure it's going to be a lot of the same with a little bit more detail, maybe
Yeah.
about each witness's testimony. But the overall is he's not guilty, which is great.
Yeah, that's just in the witness. I mean, in the
The restraining order
restraining order.
that
Yeah.
he supposedly violated on February 26th when Paul O'Keefe, through Kate Peter, invited Lindsay Gattani to court.
Yeah. That's it.
But it's a good start for all of his other arguments that he's about to have. Let's get Karen free, and then we'll focus on all of the other TV charges.
Yeah.
Yeah.
Don't you start,
Huh?
Danny.
How great would it be if Karen's free by the weekend? Like, I don't know that it would be that quick, but it would be wonderful.
Yeah, that'd be
You
great.
mean next weekend?
No,
She means
this
this
weekend.
weekend.
They're going to start deliberations tomorrow after the
Oh,
closing arguments and the charging jury instructions to the jury. She made it clear she wants them to stay till at least 5 or 5:30 tomorrow. And if everyone's on board out of the 12 that are picked, it could literally be a not guilty that quick, which would be wonderful. But it's a slim chance that it'll be Friday when we hear the verdict. And yeah, they were talking about for Father's Day, that would be a great Father's Day gift for William Reed.
That would be.
Yeah, that would be a good one. That would be a good one. Well, let's do what we do and see what this thing says, man.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so First thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of close of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened,
Wait,
such that none of these
Danny,
charges
can I
can
say
stand.
one thing while people are listening?
Nearly
to
every
this?
witness, Your Honor, we have called.
Say what?
I was going to ask if I could say one thing while people are listening to this. The defense actually asked if a charge of OUI could be added to the charging document that the jury will see on the verdict slip, which is very smart. Because if a jury feels like they have to charge her with something to give the O'Keefe family some sense of justice, if they charge her with OUI only, she won't see any jail time because this is her first offense. So that was very smart for the defense to ask for that, but they're still waiting for Judge Canoni to decide on that. Do you get what I'm saying? I can't hear Danny. Can y'all hear Danny?
Every single time.
I hear you now, Danny. What were you saying?
I said the moderators probably just gonna have one per chat. Sorry, can you hear me?
Yeah, I hear you.
Probably just one per chat. Or per,
But when
per
I was
stream
talking
or something like
about the OUI, do you understand the importance of that?
that. The OUI. Good, do it again. I was reading.
No, I
Like,
was saying basically I feel like the jury in trial 1 was trying to split the baby between the prosecution and defense and to give some sense of justice to the O'Keefe family by finding her guilty on a lesser included of manslaughter. But the jury, the defense this time asked to add OUI as a charge of count 2. Not that she committed manslaughter or murder or that she hit him with her vehicle at all, but that she was drinking and driving. So they could conclude that, yeah, enough evidence has been presented that she was drinking and driving. And in their minds, that could possibly split the baby to where she doesn't get away with this at all, but that she didn't have anything to do with John's death. I think that was extremely smart for the defense to ask, but Judge Canoni has not decided on that yet.
mm-hmm.
What
Dean, what trial testimony did you watch yesterday? We were
What-
going to try to do
I
this
watched
yesterday,
the
but I
Karen
got
Reed case.
sidetracked. No shit.
Yeah.
No shit.
Hell
I mean,
yeah.
she
Jesus.
admitted that she was drinking and driving, but the whole extrapolation can't prove that she was 0.8 or higher based on how it was conducted and based on they have no evidence of whether or not she drank once she got back to John's. But let's just assume that that's something that the jury would feel comfortable in charging her with, just to not let her get away scot-free. That is a much lesser charge than any one of the other subcounts of manslaughter that they originally had on the verdict slip.
Not for sure.
I mean, she literally would not go to jail at all over that, which is
Yeah.
a huge win.
Sorry, this thing is running. It makes it slow. Seems like I might have to turn it off every now and then.
You're good.
Yeah, it's making it funky.
We would submit has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that the 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakith has confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry.
You just said Albert, you mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who was on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right, thank you.
Thank you, Your Honor. The Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that Ring camera video. Essentially, the Commonwealth would submit that the
Okay.
I can't hear Danny. Can you, Dean?
No, I don't think he was talking.
Oh.
Okay, so guys.
Yeah, Dean. What
as he's
how do you
going past
feel
doing
about
his
the
duties.
Oh, there it is.
What is it?
Nothing. Nothing. It was just paused for a while.
Yeah, the testimony stopped. We thought you were talking. We couldn't hear you.
No, I think it's just I just turned that thing off. So
Hey,
Yo.
I think it's
what's
done.
up, guys?
What is peer-to-peer connections? Something. I think that's our phones and shit, or talk links or something.
I'm so excited. We're on the new channel. It's been so long. I missed you guys.
I know everyone's excited to be back. This is awesome.
Yeah, I had no idea because my Discord doesn't give me notifications anymore, and like this channel isn't at my like beginning of my channels that I watch on YouTube. So like I didn't see it at all.
Well, as long as you hit all notifications, it should still show up.
Yeah, it does, but I have like a really long list,
I know. Same way.
and it just like disappears. But it always gets up front, you know. Now that we're doing stuff here. Sorry.
No, I asked in the chat, how long does everyone think a verdict will take? And I'm waiting on other people to respond.
So what I think is that they should come right back. And if they don't come right back, I'm worried. I mean, unless they really want to hang out for another day, I mean, it should be pretty easy for them to just be like, dude, like, I don't know if it's supposed to be this obvious. Like, they're probably going to like question it because they're like,
Well, they have a lot of evidence that they have
Nothing
to
on
give weight to.
still-
Like, I feel like if they come back quick, it's not guilty. I feel like if they come back Monday, it's not guilty. Past Monday, I feel like there's some holdouts that either are going to end up hung jury or that they have to persuade to not guilty.
right, I feel the same way. If it's not Friday or Monday, something's wrong. and it's probably plants. But I'm very interested to see how they choose the alternates and the foreman. It's a lot
Yeah,
of
like
stuff.
if it's based off of the seat, that's concerning because the person that they moved to seat 1, who was the foreman last time, was not in seat 1 at the beginning of this trial and who got moved to seat 1 after the
The flirty
question.
kids.
Yeah, right. And the person they put in seat 1, who I understand is a African American who's not taking any notes.
Yeah, he's not
Nothing
guilty.
and has
He's not
anything
guilty.
to
We're
do
good
with
with him.
African American, but it's someone not taking notes at all, and he's the only one not taking notes.
Yeah,
We
because he's had his
just-
mind made up. He's had his
we-
mind made up. He's a young man too, so he's like,
Hey, Cheryl. What up, Cheryl?
They're bringing race into it, Danny.
Don't do it.
Don't.
No,
I'm just
what's been-
kidding.
That's
But
what's
the
been
way that
reported
Turtle Boy
makes
described
me
him,
think that he may be someone who's against law enforcement and doesn't care to take notes because he's so anti-law enforcement from the get-go.
Yeah.
so that's where the way that Turtle Boy describes like how he's sitting there, because just hearing it from like Sue O'Connell and stuff, just one guy isn't taking notes. But I didn't know that he was young, and I didn't know that he was like black, and I didn't know that like he was just like not, he didn't care. He like wasn't paying attention, you know? It's not that he's like, I don't know.
See, Prince Lover says that she thinks that seat 1 is automatically the foreperson. I have not heard that. I mean, in
Well,
trial
I mean,
1,
that's really the
Bev
only
appointed-
explanation. That's really the only explanation for why she just got to choose the one
that
last
to
year.
me is absolutely ridiculous that you would vote the foreperson based off where they're sitting. Like, to me, it would be based off of you watching them throughout the trial and how attentive they were, how much notes they took, and that other jurors would agree that they're a good foreperson. Basing it off the seat to me is absolutely ridiculous.
Yeah, I mean,
Well,
it's
I
supposed to be
think,
like that show Jury Duty.
I think typically like the jurors vote.
Yes.
Not
Exactly.
in Massachusetts. Not in
No,
Massachusetts.
nothing's normal here.
Oh.
And
But-
nothing's
but
normal in
also-
Bev's courtroom.
But even in Massachusetts, this has been the first case I've seen in Massachusetts where the judge voted the foreman before the alternates were picked. It's usually after the alternates are picked. So I think
Yeah, I've
things are
never-
done
I've never
differently
heard
in
that.
her court.
Yeah, and I'm not saying I like go to court a lot in Massachusetts, so I'd know, but like
But
I've never
I don't
heard of
go
that
to
before.
court in Massachusetts, but I've watched other cases there, and that bothers me.
Yeah. Yeah, I haven't
Every,
either.
every
I haven't
other
watched it.
trial, the jury has picked the foreperson based off their knowledge and attentiveness.
Yeah, that's how I thought it goes.
Yeah. Yeah, that's
Oh, I
Trying
weird.
guess
to
that's,
find, I'm trying to find all this setting up for the people in the chat, like subscribe to talk and chat and all that shit. Cannot remember where any of that stuff is.
No, Cheryl, that sucks.
Oh, so you want it subscriber mode only?
Yeah. Yeah, I do.
No, that's smart.
But I gotta go back because the channel's new, so nothing's like been
Wait,
clicked on.
so is Prince Lover saying she looked it up last year and the person in the first chair is automatically the foreman?
No, she's saying in Texas, the jurors choose their own.
Mhm.
I mean, that's how it is in every other case, but I thought she
Yeah.
commented earlier about seat 1 is automatically the foreperson, I thought. So I was
Well,
asking, like,
It might be Bev's rule.
Stacy.
Yeah, it looks like the court decides. From
the
what
court
I'm
should not
reading.
decide till after alternates are picked, though. That's ridiculous.
Cherry. Yay. Hey, Cherry.
What's up, Cherry?
Thanks for coming and check out the new ride.
Yo.
This is my bike. That's my bike too. but we're gonna be a lot safer on this one since Cherry's in here.
Did
Gotta
you see
wait
the new
for-
Microdots clips? That's a good one.
No, I haven't seen it. How long is it?
I think it's like 40 minutes or something, but it's just all Rentschler like making Brennan look like an idiot.
Yeah, I bet.
Yeah, it's just like a montage of all the times that he owned him.
I want to watch that too for a little while, so we might
Yeah.
want to get after it.
Yeah,
I'm
it's
just
fun.
curious about what in the fuck is Lally doing up there.
I don't know.
They
Brennan's like,
woke him up. They woke him up
What?
right here at the end. Like, get up there and put him to sleep, Lally.
Brennan's like, it can't get any worse. Let's just let Lally take it from here.
So did anything come out today about fucking Welcher chicking out after he saw those fucking X-rays and he's like, y'all fucking lied to me, motherfuckers. I'm not coming back up
I
there.
mean,
anywhere
it
near
has
it."
nothing to do with Welcher chickening out. It has to do with Brennan chickening out about not calling him back because he could not resuscitate him, and there was
Well-
nothing he could say that could contradict.
What's he gonna say when
Arca's
Alan
testimony.
Jackson rolls those damn X-rays out? He's like,
He
hold on a
can't. He's,
second.
he's
Let
gonna
me
have
read
to
this
eat the
back to
crow.
you.
He's gonna have to eat the crow then.
Gingy fell asleep.
But you know, Welcher hasn't gone and done testing that could contradict Arca's testing. So there's nothing they could bring him back on that would help the Commonwealth in any way whatsoever.
Yeah, he
That's
just needs it
why-
to end.
That's why Hank is like, no, we're done.
Yeah,
we're
like
not
his
gonna
best
bring
course
in
of
the dog
action.
DNA. We're not gonna bring in We're not gonna bring in Crosby to talk about going up and finding Chloe and measuring her teeth. We're done.
Mm-hmm. Oh, 137 is Microdots. I see. Wow, this channel's a lot more strict.
What is it?
This channel's already
I'm reading
the-
some weird stuff, so I'm not sure.
okay. No, I'm not criticizing. It's just like in the beginning, it was like everybody gets a wrench, and then it's like maybe not.
I was gonna go pull up Microdots video, and I was looking at it just now. Is it about the cross being annihilated? Is that the video you're talking about?
Yeah, I guess it's like an hour and a half.
Sorry, I'm stuck inside this stuff, trying to get it to go. So let's watch some testimony while I look through this stuff. I mean, not testimony. Let's see what Lally's doing.
Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There's been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to do this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay?
All right, so regarding the charge. So we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw two of our requested instructions with shorten things today.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that.
Okay. And what else from your proposed instructions? You said there were two. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right, you filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Leskinen. Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions? Okay, so we're gonna,
Can't pin the link yet. It's not letting me log into Safari. It's confusing the two channels. I'm trying to do it.
go through them one at a
You got
time.
this.
Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yeah.
All right, so model homicide instructions and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, Commonwealth does have a request for, and I understand, what Christian might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking instruction on third column.
All right, so we will deal with that. I'm going to go through the defendant's instructions or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So
Hey,
presumption
Betty.
of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some
This part is
further language
ridiculous.
on that.
Listen
You've got
to
an
her.
instruction and a proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So
Sure you
I will
will.
make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction, third party incorporate, but the Commonwealth will be making a request that counsel be prohibited from making a third party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses who stand. Exhibits that were put into evidence or anything of the like. So in the instructions and the arguments are based or predicated in the case law on evidence. Not, obviously, it's well aware there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. But the Commonwealth will submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only both or third party instruction, but specifically for even counsel to make that argument during the course of the vote. And I understand Bowden is a little bit more loose as far as the word certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material, evidence, chain of custody was
Oh, y'all better hit the light. 4 of y'all in here hadn't hit light. Jeez, y'all are lazy.
contaminated and corrupted. There was evidence of the bias, the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a philosophy cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a voting defense.
Okay, so you can get into third-party
Does everybody
culprit with
understand what's
Brian
happening
Higgins,
right now?
that the police were aware of
Yes.
whatever
Let's name it.
you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay. Yeah. So Ms. Gianetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, all of us have an objection to the DTP instruction. That's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Gianetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right, so, obviously it's not the strongest DT argument that we would have, did not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done, it wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording, so we still think we're entitled to.
Do you think it was custodial interrogation?
So
Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Hill?
I would also add, Mark,
Sure.
they did seize her vehicle at around the same time. So, that it goes to the issue of custody and my client being able to deny it.
All right, what do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody, she was arrested. Yes, they did seize her cell phone and her vehicle, based on information that they had developed over the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have placed as far as there's already been within the same request jury instructions or request for humane practice, and then following the DAG and FISA language and the request jury instructions, there goes on to all of those other requests regarding your compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have his testimony from the stand. And initially she said she wanted to be fine with answering questions that they wanted in any details. And then when the questions became centered on, or more centered on details, at that point, I know that's not a jury, but of course, where she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. I don't think that it rises to the level of the case instruction. So I would ask basically that everything on page 8 prior to the instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies in the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the,
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the drop that they saw on the view was not present on January 29th. You got one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
I might just reference that.
Sure.
Language in there that I would object to.
Okay.
That's when a police officer or someone else works for a law enforcement agency.
What do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be fine.
Okay, thank you. Do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I'll cover all those topics. What page you on? Okay.
One suggestion there was, in case, home office issues photographs and evidence, I would submit.
Yeah, I'm just going to say,
Sassy, you gotta have 500 subscribers and 3,000 watch hours. And we
Start
were
from scratch.
2,200 watch hours and 250 subscribers. We were close.
Out the window. But we can do it again. We don't give up.
Yeah, but those watch hours are hard to get, boy. That's the
I
hard
know.
part. Well, I mean, once this trial's over, it's really gonna be hard to get subscribers. You know what I mean?
I think we can pivot.
Maybe. I mean, it may not be. Not like everybody's just gonna quit.
No, it's a
streaming.
place for everyone to stay, to stay together. Like, we don't want to just like disperse after the trial's over. I think we still want to hang out, right?
Oh,
I
yeah,
think it will get more popular.
most definitely.
That's right. We just got to hang out more. That's all.
That, and I'm not putting the fucking chat back up on the screen. I can tell you that.
That's probably
Because,
smart.
I mean, you can't take it off your stream then.
Yeah.
Like now, people can say shit that's not so visible in the chat.
Right.
You know what I mean? I'm not putting live chat replay on or any of that shit.
The good
See?
thing is your wife has such knowledge of Coburger that you could jump into that and gain an
Oh, we are.
audience there, and you've got
I'm
us
interested
going
in
along
that.
with you no matter what.
Lawlene, you sound like you jumped into some yellowtail Chardonnay.
No,
You've been
no
in, you've been in that
yellowtail
pool.
Chardonnay.
You've been in the pool sipping on wine.
No, my pool is green because of all
Oh.
the rain and the algae, so I've been treating it all day.
Ugh.
What do you do? Do you like shock it? I remember.
Oh,
Yeah,
Oh,
I
yeah.
have to shock it and add more chlorine tabs. So yeah, I've been doing that today.
If you
Do you
use
ever think
liquid,
this?
if you use liquid chlorine, you won't have to do it as much. When you use the tabs, it adds calcium, makes it.
I'm
Makes
having to do
algae
a
grow
lot
faster.
on my own right now, so I'm just doing what I know without
Oh yeah.
getting any
But I'm finna
expert.
tell you, how many gallons is your pool?
Like 13,500.
13,500. All right.
It's
So
like the kidney bean shaped.
yeah, so you get gallons of the chlorine for the pool in liquid. All right. So it's cheaper than the tabs overall, and it doesn't add any calcium. So you use the algae killer in the liquid and the chlorine in the liquid, and you'll put less stuff in the pool eventually.
I have
It's
to
the
look
same
into
fucking
that because I know I've bought like buckets of the calcium stuff that I couldn't get on my skin or smoke while I'm putting it in because it could be flammable. Like I did all that one time, but
Yeah, it's easy. You just add 2 gallons of the chlorine and 1 gallon of or a half gallon of the algae thing, like every 3 days,
thank you, Dana.
and it's super easy. I mean, you still got to clean the pool out every week to 2 weeks. You still got to vacuum it out.
Yeah, it just drives me nuts that
And
every
you
time it
still
rains,
have
my
to,
water turns green.
You still have to powder shock it once a week too.
Yeah.
You
I'm
powder
doing
shock it
that.
and use liquid chlorine, man, that thing will be crystal clear and it won't have as much calcium, so it won't get dirty as fast.
Yeah.
So I'm going to mansplain for a second because I don't really know anything about pools, but I do know that my dad would always complain about having to take care of the pool. Like it was his least favorite chore. He still lives in the house. He still has that pool and he switched to salt water.
Well,
And
that's
it,
the thing, Mary B. When we bought this house, it was a saltwater pool with all of the saltwater equipment, but it had gone out. So we requested that it be like repaired
Mhm.
where it would be easier, but they refused and we couldn't really fight them on it. So they left like tons of chemicals here. And I was like, okay, we've had a pool in the past. I can do it with the chemicals. And we were able to the first 2 years, but this time I'm on like, less income to treat it the way it needs to be. So I'm having to
Well,
do
the
a lot
liquid's
more work.
cheaper. The liquid's a lot cheaper too. You can get it. I can't remember. It's like $5 or $6 a gallon, and 1 gallon treats like I think it's like 5,000 gallons.
Yeah, exactly,
Yeah.
Stacy. Like my entire childhood is my dad threatening to fill in the pool if we don't start using it more. That's like the whole time. So like he literally just switched. Like I obviously don't live there anymore. He just switched like a couple years ago and he's like, dude, it's so much easier.
Yeah.
What's sad is I'm the grown up and I'm the one who uses it the most. Like the kids will use it when their friends come over and stuff, but like on a daily basis, they don't get out here. I'm the
Yeah.
one out here in the evenings cleaning it and then getting in and like swimming for exercise and stuff. But yeah, the kids don't get in it unless they have friends over. And
Yeah.
it bugs me so much.
All right,
Yeah.
here we go.
That's the thing.
Here we go. Here
right,
we
sorry.
go. Let's do it.
Little tangent.
Say there were photo.
Oh, we can watch that microdots thing.
Yeah, I
I hate
sent it to you.
I hate to get any kind of pings because those dudes, I don't know. That would make it. Whew. That would be too quick. But we might watch it in here in a minute after this.
Photographs that are in evidence. Was that the nature of your objection?
I actually think that defense has introduced more graphic.
Yeah, so I would just say you've seen photographs, or there were photographs in evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, not or, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks.
Okay.
And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something preface it, witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
Okay.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instruction, but we're joining in the almost request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through The limiting instructions I gave, I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
You're right, we're looking at two Aruba. We don't believe that there was really any testimony that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So,
We would object to the part of that act being linked to the Higgins text.
all right. I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on call.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second degree murder and where you're saying I should not this year, Mr. Lally.
So the only,
1 second. Let me just pull that up. Okay.
Your Collins request is clearly not for any change or alteration in the instructions that were given, other than there are three prongs of malice. And essentially, the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially extraneous to the situation, and you don't see expectation of the jury. Avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. She's not intending to do that. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing.
Okay.
You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll defer to the court.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We look, I don't have it.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason. I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the penalty.
If I alter it, it means I remove those two. That's all.
Right, no, we just want to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So lesser included offenses. Did you want to know UI instruction? You were
We're asking for that.
okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court on the Commonwealth. We recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
I'm going to give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a.
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So,
I'm sure we can be in touch this afternoon. I do not believe it's going to be a problem.
okay.
Just a couple other things before we get to Mr. Alessi.
Yep.
One is that we do have the Dr. Wolf PowerPoint to be introduced in evidence, Your Honor.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so.
Okay.
It's on a contract.
Okay. The Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we have proposed verdict slip for count two, Your Honor. If I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth. Can I hand
Okay.
the court's copy to the court?
Sure. Is it the same as last year's, but now with a,
It's different.
okay. All right.
So we have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead. I'll hear you.
I'm actually United.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after the trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment.
Damn it, Dean, I cannot find where to turn on subscribers mode only.
Cherry already did it for you.
Oh,
Yeah, I thought it was on. I saw it in the chat that it was on that.
Yeah, Cherry did that for you.
Is that what you've been doing this whole time?
well, I got a whole lot of all my descriptions and everything.
Oh, okay.
She's gone.
That's hella funny.
Ain't got no gas in it. You
Yeah,
know what I mean?
gotta set it all back up.
Yeah, I remember now how long it took. But see, this time I actually know how to do it. So I keep getting lost doing it real quick.
Yeah, you have experience now. Hey,
Like
Danny,
doing
do you
it.
see my Diet Coke?
Dean always does it real quick though.
I'm what they call a minute man.
Tombstones, what's up? Hello, Tombstones.
Did you see it?
What?
My Diet Coke. Fiona, move.
No. Oh God. Only my name's not Daniel.
Oh, it's not?
No, it's not. It's
It's
close
just-
though. That's kind of weird. It's a little
Daniel
close.
some.
I
And they
didn't
just-
know. I didn't know if you just used like Danny was just like a nickname.
Nope.
Okay.
Nope.
Well,
The
they didn't have a
nickname
Danny.
Is the name. The nickname is the name.
Oh, and also, Cheryl gave me this awesome bracelet. I'm obsessed with it. Can you see it?
Nice. Nice.
Like I haven't taken it off. It fits so nicely. Like usually I can't wear like jewelry and stuff because it's just like bothers me having all this stuff on, but this one, like, it hangs out. I like it.
Sassy. That's not
Danielle.
funny. That's not funny at all. This is getting out of hand already.
I think he's
Again.
more of a Daniela.
Thank you.
Danielle.
Thank
That's how they say it in France.
Say it with an accent, you know?
Danielle.
No, not
Is
that.
that
Not
right?
like that. Not like that.
Not like that, not that accent.
I think Dan and I both agree. we should
Danielle?
never do that again.
No,
Never.
I think you should do it every time you're up here.
Well, I'm practicing my pronunciation because I am learning French on Duolingo. But I actually switched to chess lately.
What?
Did this just become an
What?
ad for what was it?
Duolingo?
Guys,
I'm
everybody please go to the link in the description and use code Daniela.
They should be paying me for that. I do talk
No,
about it a lot.
YouTube does not like it when you post links that take people away from YouTube. What they say.
Oh, okay. So
Is
we're
that
learning
correct?
all the things that piss them off. That piss
Well,
off the
I've
YouTube
read
gods.
about 17,000 pages worth of crap this week.
I know. Who can read those? They're so long.
Me?
Oh, tombstones. We should be friends and like share each other's progress.
What? Ah. You are gonna French each other? Ugh. Let's get back to this. Dude, this is crazy. They're both
Yeah.
doing French.
This
They're
is
doing
crazy. Danny,
Yeah.
maybe we
Getting a
should
little-
French
getting a
each
little
other to like
NC-17 in
cancel
here.
out
No.
the female gayness
No,
by
let's
doing
keep it
our
more
own
like-
gayness, and that'll cancel it out.
No, let's do some Espanol.
Damn
Let's
it.
don't do some Francois. Okay.
Oh yeah, I see what you're talking about, Cheryl. I bet you the glare likes that look.
Oh my God. Back to this.
Because the number of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable with
Exactly.
there being one
Okay.
option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports the defense requested, that the court must get it. Having said that, the verdict slip that was used in this matter.
Oh, is this when she throws the mic at him?
Is more than sufficient, adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Lau, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy of it. But
Lally, go to the podium, lazy bastard. You did
No,
all
the,
that studying. He did all that
the-
studying to get that law degree, and then won't even take his ass to the podium like everybody else and make a spectacle like a lawyer's supposed to.
Yeah, he's just lazy. He doesn't want to walk all the way over there. But court reporter is going to throw the microphone at him in a minute. It's kind of fun.
Oh, I like this.
That may somewhat helpful, of course.
Okay, was that on a murder case?
It was not, but it had to do with the felony movie of homicide.
Yeah, I'll take a look at it. Mr. Kirk. Mr. Kirk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Wells is an excellent judge. We think that this verdict slip is, it provides the most clarity to the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy, please?
sure.
This is the-
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Just one request, circling back to the constitutional field instructions. So Commonwealth was withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument with reference to the arguments of the jury related to specific areas which we need judicial approval before we. So the two areas that are sort of listed within that we would like to make some argument with the jury regarding is the defendants taking up the license from one mental health and to a parent's residence indictment, and then certain statements made in reference to the various clips of the later statements.
Okay.
In particular, would be the one where essentially she says it's a that came to her.
Okay.
The exact location of it.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we think that, to that, I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. And in fact, on the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other.
Yes, so I did want to ask you though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay,
do not like it.
okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redaction.
that's great. Thank you. One less thing you all have to do today, okay?
This is Mr. Lewis.
I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me? The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just, 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealth's.
This is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Mr. Yannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
I- it should come out.
Yeah, so we'll switch it back to ID
Yes.
and this will just be 209. All right, did we have an ID number on it originally?
NNN.
Can it still be that?
Is it exactly the NNN? Or is it, no, it can say that.
Okay.
Right, 'cause this is-
Oh, it's just NNN. It's not,
Well, where did it?
no, it became 209.
So that has to
Our
be-
thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
And then the redacted version will now just.
209,
Yes.
yep.
It's Janine's best friend.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What Commonwealth will submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the final part.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Leslie.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan. And Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer.
Hello, Misty. What's up? Yeah, I was lost in it. Plus, I'm trying to add things back that are all kind of jacked up.
Oh, like add in like all the videos you had in to the last one and stuff like that.
That should work.
No, I was just curious. I was just asking.
I got 50 hours of StreamYard.
Nice.
Well, like 52 hours in StreamYard. But I don't think they would, if I uploaded those videos, they would be too happy about that. So it's not on YouTube. It's
I don't know what you're talking about.
Do you want me to ask AI?
StreamYard keeps the a recording too, just like YouTube does.
Oh, yeah.
So if I wanted to, I could just.
I'm going to ask AI all these questions, and I'm going to give you some, like, a list of what you can't do.
Oh, yeah.
Me and AI are tight.
That's what everybody thinks until the Matrix.
Yeah, well,
No, I'm just joking.
I keep on using my manners. I've asked it about 1 million times if, like, it was going to take over the world, and it has assured me that it won't. So,
yeah, I watched a video. Sorry, not to get off topic. I watched a video the other day of this person who is faking an injury, and they have this AI robot that like helps them. And the AI robot got mad and slapped the dude for faking an injury, and I was like, "Oh no, it's starting." It's fucking starting.
I would actually program something to do that though.
Sounds legit. Did you see that
Yeah.
black cat?
I think that's a good idea. I think people do need to be slapped for faking injuries.
Yeah, but from an I don't know, man. It was just messing with it too. It was like, oh, look, I've got a busted leg, and it walked on like the leg that wasn't busted, so like the AI knew, and it just straight up smacked him. I was like, no.
Was it supposed to be like Baymax in Big Hero 5 or 6?
A Betamax?
Oh, I thought.
Is that what it is?
Yeah, it's like the big puffy guy.
No, it was like a humanoid type robot. I mean, I guess that's also a humanoid. It was like more shaped like a human.
Right, not like the Michelin Man.
Yeah, exactly. Not like Danny. Nah, just joking.
Oh, what? You were talking to me?
No.
Yeah, he's not even paying attention to us. You want to come
I'm
up
just
and say
kidding.
hi, Freya? Yeah.
Fiona.
No, Freya might come up.
Oh,
You gonna come up, Freya?
the elusive.
No, she
Dean, where are your cats at?
Downstairs.
That was a quick answer. How do you know? Maybe they're outside.
Because they sleep downstairs.
You want to come up? Come on, Freya.
That was a quick answer. So we got about 8 minutes left into this here video.
Let's do it.
Let's do it.
Observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not
The
rejected?
testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it.
What
So that
happened?
we couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally,
Very briefly,
keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay, so I'll consider it, Mr. Alessio.
Thank you, Your Honor.
All right, anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have. Judge,
They don't think it's
during
fair
the last
that you
trial,
got
during
somebody
deliberations, the court had asked us to be
end up
5
with
minutes in
nothing.
the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right. So we'll see counsel in here no later than 8:30 tomorrow morning. So counsel here at 8:30. All right.
Gets
Thank you.
earlier and earlier.
All rise for the court, please.
Is there already one of these, like, are we swapping?
Yes.
Goodbye.
Goodbye. So. What do you want to watch next that's not the microdots? I'd be scared to watch it tonight.
Does Turtle Boy have his trial up?
His trial? It said it was going to put it up.
Yeah, I
Let's
can
see.
look. I think he was planning on watching it.
On the Turtle Club.
Yeah. Yeah, it's not up there yet.
We definitely got some Ranchler.
Oh yeah. My Alessi story. I have an Alessi story. So I was there. I was there on Tuesday. So rainy out. It was miserable. Like I sat out there and like got soaked. And it was so miserable out. And like nobody ever came out of the courthouse. Like I didn't get there until after the break, but apparently they didn't come out for the break. They usually come out to get lunch. But they were kept in the courtroom to argue some stuff like during lunch. So they didn't have that long to eat. So we're like sitting there waiting for them to come out. They don't come out until Alessi comes out and starts booking it down the street, like running like a track star down the street. And then Dina starts running after him. She's like, you should have just told me to get you something. She like continues to run down the street after him. So they're gone for a while. We're still waiting. Dina ends up coming back. I talk about the channel a little bit. And apparently when Alessi went down to like the sub shop or whatever, there are these people that are there every time that I go. I forget their names. That's awful. I don't really remember names, but they're always there. And they met him in the sub shop, and he like took pictures of that with them and stuff while he was waiting for his sub to be made. And then he comes running back, and he's running by us, which is like the end of his run. He just ran there and back. And he's like, see, not even out of breath. And he ran into the courthouse with his sub.
Damn.
I was like, I freaking love this guy.
Yeah, so we got to get Clerk some stuff, some links to drop in the chat. Got to make sure you always got the Karen Reed Defense Fund ready. And we need like some disclaimers about people's behavior up in here. Right, Dean? Where do you get the disclaimers at?
I mean, I don't know. I don't ever mess with that stuff. I never worry about it. But I also understand where your concern comes from.
Yeah, just want to drop a little disclaimer in the chat every now and then. No racism, no disparaging comments, no.
Tombstone.
There we go.
Jesus
Just
Christ.
like that. Just like that.
That's hilarious.
Oh, but yeah, so that was the day of Dr. Laposada. Her testimony, like we were outside listening to that outside the courtroom, and like holy shit, this lady's a gangster. She was awesome. And then I saw her when she was done testifying. She came outside and she was like chatting with two ladies like just right in front of the courthouse, and we waved at her and she waved back. She was cool. I'm down with that chick. She was gangster. Like seriously, she did not give a F. Can I say that still?
What?
The F word?
Sure.
Okay, so she didn't give a fuck. She was just like, dude, you're wrong. He didn't get hit by a car, so that's not relevant.
Yeah.
And she said bullshit. Didn't she say bullshit when they were talking? They were talking about the Rhode Island station fire and how like they said all this bad shit about her. And she's like, that was bullshit. You guys suck.
What in the world? How about we watch some Rentschler?
Okay.
Let's watch Rentschler's Cross. See
Yeah,
what
that's the best part.
That good with you, Dean?
Yeah, dude.
Oh, shut the fuck up then, so we can fucking.
You can never get too much Rentschler. He's awesome.
You can wrench too much, but like he said, anything's possible. Spaceships could have landed for all we know.
Anything's possible when you make shit up.
Yeah, when you're just making stuff up, like
Yeah, definitely
I can go
possible.
I can go twice as high. Take a look.
Yeah, it's
Read
in a
it.
book.
Mhm. I thought you were shutting up.
Never.
Okay, good.
Fucking make me. I'm gonna talk all through this testimony.
Hey, this ain't the movies.
All right, Mr. Brennan.
Dr. Rentschler, facts matter, don't they?
They do, yes, sir.
You said it many, many times. Facts matter. Isn't that correct?
It was details, but facts matter too.
Do details matter, Doctor?
They do.
They're critical, aren't they?
You already get
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the question.
Dr. Rensler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
What exhibit 2, please? When you were giving your estimate 10 to 20 feet, Dr. Rensler, did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
So when you look at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Rensler?
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do, yes, sir.
Take that down, please. Did you speak to anybody today before you testified about Dr. Welch's testimony in court?
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welch's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was
He was 73 inches, I believe.
he? So that is not a representative height and weight for Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections analysis based on limb widths, it would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the Hybrid 3, and I use a Hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the Hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the Hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration, but the acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio of force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it did not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it
Our
with anybody,
kids.
you said?
I did not know.
before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you? Yes, Your Honor.
Okay, we can approach briefly.
Before you testified last year, you were receiving information, not from the defense, from your employer about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense.
You know, I had to go back and like do some bunch of my subscriptions again. And Melanie Little, when you subscribe, you have to wait 24 hours before you can chat.
Ooh. That is a long time.
Yeah, wait 24 hours before you can chat. A lot of them are 5 minutes or whatever. But she's like, fuck that. You like today, you can talk tomorrow.
Defense, I had no idea what was going on. We were retained by a certain
not
organization,
today.
and they contacted.
Sorry, I'm back.
the court. They were in talks with the court about, I guess,
Damn
what
it.
we could or couldn't do. Anything I got was from that organization.
Voir dire 2, 118, line 15. Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all. No, it doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific answer.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't.
Night, Angel. What time is it? 10:30? Yeah. I think
Night, Angel.
Ride this thing about 30 more minutes, put her up, see what happens.
Yeah.
She's got a nice feel to her, though. You know, smells like a new car. Kind of. Till Dean got in the back seat. Now it smells like a sweaty new car.
Hell yeah.
Why do you smell sweaty? That's what I don't understand.
Why don't you smell sweaty?
It's the internet, though. Why do you smell it all?
I was watching Cops.
Oh, you're watching.
Oh my
You got your VR headset on and you're running around the living room. Hiding behind the garbage cans and stuff.
Didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Doesn't matter, so let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? You're denying it.
I'm going to allow it.
Yeah, I don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question. Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
I'm going to allow that.
I don't even think that it did. I don't understand it. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mhm. Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
You don't believe?
Yeah, there was no need to.
That's not the question.
Night, Cheryl.
It
Night.
doesn't matter.
Good night, Cheryl. Boots on the ground, Cheryl.
Was there any attempt?
So the objection sustained. I'm going to strike that, folks. Okay.
Night, Cheryl. Free Karen Reed.
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took the ride. If I wanted to appear independent, then I would have taken an Uber.
Have a conversation about it, that you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Did you have any bias more in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
Had a ham sandwich. Did you testify at some point that
This is
after
the
you
best
had
part.
something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
How long does it take to eat a ham sandwich?
That's the question on everyone's mind.
How long does it take? That's pretty fucking hilarious.
Yeah. Crazy.
When you sat at the table and eat, did you just eat your ham sandwich? Or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Certainly, I'm sure I did, sir.
Did you laugh a lot?
He's fucking human. What do you think he's gonna do? Just sit there with his fingers in his ears.
I took off my listening ears. Just
Yeah.
felt like it wasn't appropriate.
Yeah, I didn't want to listen in on human activity in my immediate area. This is the stupidest questions.
Yeah, it's ridiculous.
And it just doesn't get any better. He doesn't go into any substance with him. He's asking him just off the wall side bullshit. Like
It's nonsense. Nonsense.
who he talked to and shit. It's like, motherfucker, I'm a goddamn engineer, PhD, biochemist. What the fuck are you talking about?
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
I don't, at this
assume.
point, I don't even remember.
Let me look at something. When you were there at the luncheon, did you see a camera crew
I
He
believe
calls
I
it a
did.
luncheon.
filming and documenting? right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage.
That's fine. I could care less.
So do you think maybe you were talking about the case and your answers and laughing it up a little bit?
I have no idea. Possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember?
what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Because you're a biochemist.
fuck.
You were having a conversation.
But I honestly think he probably could fucking remember it if he wanted to. But it was so minuscule. And I get what he's saying, but this dude's, his IQ is probably like 145 or some dumb shit like that.
Yeah, I
Because-
sent you the video of when we saw him.
Oh, when you saw Rentschler?
Yeah, Rentschler came out.
I hate you, Mary B. Not, I don't hate you, and I'm not trying to be.
I know.
Use that strong word. I just have strong dislike for your boots
Well,
on the ground, meeting
you
these.
can hate other people too because the video shows Janine and Robin G.
Hanging
What?
out with Dina. And
Yeah.
You probably
Yeah,
been
did
down
you
there
get
with
that
James Nelson
timestamp
and
of
been down
Resistance to Silence when we talked about you?
there. I saw it. Yeah,
Cool.
I did see it. I watched all that, but I wasn't in a good headspace then because I was
Yeah.
trying to figure it out. Because usually you get like some warnings and shit.
I know, it's not fair.
The last thing that I got was only the second thing. The Metallica was the first thing. That was like a hardcore fucking hit.
Hmm.
Then the Joe Flipper hit.
Oh, okay.
That
So-
little bit of the song, because you only got to pass like 4 or 6 bars in a song, or
Mhm.
you're fucked.
Yeah.
Which they don't even really take people down for copyright because look at JFK.
I know. That's what I'm saying.
So, unless it was what people were talking about in the chat, which is my fault because everybody in the chat was the damn moderator, so that made it worse. Whatever happened because a moderator did it.
Right.
So I seen
Well,
that.
learning experience. We'll get back there.
Yeah, that was a lot of hard work for all of y'all, though, being out there, getting people to come to this rat cage,
I know. I know. It's such
boring
bullshit.
people to fucking death. But people do really sleep well, after they
Yeah.
listen to me talk about nothing.
And that's important.
It is. Sleep is good. Like Dean right now. You hear him?
I'm sorry, what? Were you saying something?
Yeah, sleep is good. Can someone tell Little Miss that? She's not here right now. She's probably sleeping, which is good.
Yeah. Yeah. I don't think she knows about this yet. She's not very good in Discord, so
Yeah, we'll have to tell her.
These folks,
she'll figure it out.
and you were laughing about when the prosecutor asked you about other evidence like DNA. You had a response where the physics doesn't change. Remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich?
The
Best
soundbite.
answer.
Soundbite
Best
of this trial is awesome.
Oh my God, there's so many.
It's ridiculous.
10 minutes?
How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
Sandwich, and then you told us you stood in the corner You got a ride back
Good
to
in
the
the
airport?
corner.
I did, yes, sir.
After you got back to the airport, ultimately your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote the time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
You keep your billing?
I enter my billing every week, yes.
You know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCA. I have no idea how much ARCA's been paid.
How much is ARCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company.
Jesus, why wouldn't Bev speak up when he says I have no idea? That's his answer. You can't just ask him. So you don't know? Like, no. What do you
Yeah,
mean?
it's like, Brennan, this one isn't working either. Just move on.
Yes, Prince Lover. Thanks for coming and hanging out.
Good night.
Hopefully they'll let us fly. So we'll know in the next few days because I'm about to fucking pound the content in it. Just like it's gonna be ridiculous. I mean, like, goddamn,
Do it.
it's got to be him. Nobody streams this much. Well, I know one thing we won't be watching, Dean. Exactly.
Dean.
For the work that you've done and continue to do on this case with no idea.
It's not my concern. It's not my department, so I don't.
That's a no?
That's a no, sir.
Now, when you communicated with the defense, you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
Well, when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with, yes, with whatever I had.
Did you have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense last year during the trial?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
I'm gonna allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
I'll allow it.
It's for, I think,
Come
for
on.
encrypted.
Of course she'll allow it.
messages.
She hates them. She
Do
knows.
any of
they're
your
gonna-
colleagues use Signal to have conversations with their clients?
I'm gonna allow that you're aware.
I have no idea what my.
You gotta
fellow
watch his
employees
eyes.
Or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yeah.
Yep.
You worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
I'm gonna allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
MJ.
When you worked on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
But Scott Klein is another engineer at ARCA that worked on the case, correct?
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf are in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to you want to ask any questions about that? Objection.
Sustained.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted? Objection.
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but I'm pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
So without that Priya, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Do you, since your memory is difficult?
Sustained.
Dipshit.
It's ridiculous.
To remember things, you write them down.
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
His face, I love him so much.
You provided a CV, which is a resume.
That's correct, yes.
Resume outlines your education,
Yes, sir.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school. Correct.
Have you had any peer review articles since 2003?
Probably not. No.
And your peer review articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them. Yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with a variable configuration wheelchair.
The hybrid 3. Yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yes, sir.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
And so you would agree that all of your peer review articles deal with wheelchairs.
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter,
Yes, sir.
Smart Technology for Aging,
Yes, sir.
and again, nothing on pedestrian accidents.
That's correct.
Expanded abstracts, you've written a few.
I have. Yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology. That's correct. Yes, sir.
Any have to do with pedestrian collisions?
I don't believe so. No.
Looking at your CV, you can note any area of specialty you'd like. Correct?
You can put down whatever you like, I suppose. Sure.
Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Now, Doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at the time, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
Okay, good. And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
I'd talk to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
You were very careful to make that distinction when you were critiquing Dr. Wells, correct?
Sustained.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, you trying to get the impression that you've read them, even though you're not a doctor and you can interpret them?
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion, or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to do giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray is diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report, or were you doing a certain kind of, were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
Sustained enough.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an x-ray. Yes?
Sometimes x-rays are the best for looking at bony fractures, MRIs looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinion.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You're talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience.
I'm going to allow that.
Have you ever been involved in evaluating multiple pedestrian crashes where there are multiple pedestrians hit by one vehicle and they sustain different or in some cases no injuries? Is that gonna happen in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people in different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you see other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries? And another case where you look at where there is a similar type of collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cars? It's not something that you look for and compare between cases.
Craziest questions in the world.
Hell yeah.
Hell
It's
yeah.
reaching.
Good night, Petty.
Night, Petty.
Yeah, we're gonna do a good night too.
Okay.
That's cool. I'm getting tired.
Yeah, me too. It'll be a long day tomorrow.
Tomorrow's a big day.
Yeah, it's gonna be a long day tomorrow. That's
Cool.
for sure. But hopefully we'll still be able to do this tomorrow.
Hell yeah.
Hell yeah.
So glad we got to hang out. Glad y'all got to see me.
Yeah. Very
Try to keep
exciting.
it low key this time. Try to
We got
stay out the trouble. Stay out the ditch. But it was fun. That's for sure.
Hell yeah.
Sure was.
So we will do it again tomorrow.
Yeah,
Right.
hopefully with good news.
Hell yeah.
With what?
Good news.
Oh yeah.
Like,
hopefully.
Not guilty. Yeah.
Big party tomorrow night. Free Karen Reed party tomorrow night.
Fuck yeah.
Actually,
all
it'll be the We Free Karen Reed party tomorrow night.
Whoop whoop.
all night.
Time you asked a question, Mary B.
What happened?
Puff, puff, pass. True crime chat rats. Let's go. Puff, puff, pass. True crime chat rats. All across the world, we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. True crime social, where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rap pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. Puff, puff, pass, true crime chat rats. All across the world we coming through